Welcome back to the deep dive. If you've ever signed a work contract or maybe done some freelancing or even just managed a small team, you're working inside this legal world that's often really misunderstood. It can feel a bit chaotic, and it's full of tripwires, frankly. So today we are diving into employment law. But we're not going to be, just reading statutes at you. We're trying to pull out the really critical legal ideas you need to get the difference between, well, protection and liability.
Exactly. I mean, navigating the workplace today can feel like you're walking a legal tightrope. Do you get a notice period? Are you entitled to a redundancy payment? Can you even claim minimum wage? All of that. Every single one of those questions, it hinges on these complex legal definitions.
And that's really the mission for today, isn't it? Our sources are all about the absolute fundamentals of commercial law, the stuff that sets the ground rules for pretty much any working relationship. We're going to try and clear up three big points of confusion. First, how the law actually decides what your working status is. Second, the huge difference between the two main types of dismissal claims.
Yeah, that's a big one.
And third, the actual procedures, the blueprints for handling redundancy. So if you want a shortcut to being properly informed about your rights at work, this is it.
And we really do have to start at the absolute foundation, because everything else we talk about today, I mean, every single right, every protection, it's all gated by this one initial question.
Okay, let's get into it then. Segment 1, the foundational question of status. So this is the big hurdle. You have to forget what your contract is called for a second. Legally, are you an employee or are you self-employed? Because that whole world of statutory protection, paid leave, maternity rights, protection against unfair dismissal, it just vanishes if you fall on the wrong side of that line.
And that is precisely why the law has had to evolve beyond just looking at a job title on a piece of paper. You can't just contract out of employment protection. If the reality of the working relationship, if it smells and walks and talks like employment, the courts will step in. They'll override that label on the contract, and they'll say, no, this person is an employee. Which brings us to the legal tests that are used to distinguish an employee from a self-employed contractor.
Right. So it's not a simple yes or no. It's more of a holistic assessment of the situation. What's the biggest factor the courts look for, the most dominant one?
Historically, it's always been the control test. It's the oldest test, but it's still highly relevant. It basically asks, does the business dictate not just what work is done, but how, when, and where it's done? So if you're told to be at a specific place, using their software, following a detailed manual with fixed hours, that's a very strong signal of control. A truly self-employed person is usually only controlled on the final result, the deliverable, not the method of getting there.
Okay, that makes perfect sense in, say, a traditional office. But this is where it gets really fascinating, especially with the gig economy now. I'm thinking of a courier for a delivery app. The app doesn't tell them how to pedal their bike, but it tracks their location, it dictates the route, it manages their pace, and it can even sanction them if they decline too many jobs. Is that kind of digital surveillance, that algorithmic management, is that enough for the control test?
Well, that's the central legal fight happening right now. And increasingly, the courts are saying yes, actually. Those algorithmic pressures do amount to control because the worker is, for all intents and purposes, being managed by the platform. But we can't just stop at control because modern work is so nuanced. So we have the next test, which is the integration test.
The integration test. That sounds a bit like, are you part of the company culture? Are you wearing the uniform? Do you have an internal company email address? Things like that.
Essentially, yes.
Yeah.
It asks, is the worker actually integrated into the business's structure? Are they representing the company name? Are they in the strategy meetings? A consultant who comes in for 2 days to do one specific project, using their own letterhead, they're clearly separate. But someone who attends every daily stand-up, who's in the annual company photo, who uses the internal HR systems, they look highly integrated, and therefore they look a lot more like an employee.
And then there's the third one, the third leg of the stool, which I think trips up businesses and even the courts quite often, mutuality of obligation.
Yes, this is often the real decider in those borderline cases, especially if the other two tests are a bit ambiguous. Mutuality of obligation asks if there is an ongoing commitment. So is the employer obliged to provide future work, and is the worker obliged to accept it if it's offered? If I hire a plumber to fix a burst pipe, once the pipe is fixed, that's it. There's no mutuality of obligation.
Right. But if I run a small accounting firm, and I have a contract with Jane, the independent bookkeeper, and that contract says, we will give you at least 20 hours of work every week, and you have to be available to do it, well, that completely shifts the relationship, doesn't it? even if she's using her own laptop.
Precisely. That standing commitment, that mutual ongoing obligation to offer and accept work is a signature feature of an employment contract.
Mhm.
And when you have a high degree of control, strong integration, and clear mutuality of obligation, you have an employee no matter what the contract calls them.
So the key takeaway here, really, for anyone trying to figure out their own situation or for anyone managing people, is that the law only cares about the substance of the relationship, the operational reality, not the label. You can't just call someone a contractor to dodge your responsibilities. The legal status defines the legal relationship. Okay, so now we know who gets the rights. Let's talk about when those rights really matter most, which is when the working relationship ends badly. We need to get into segment 2, the dismissal deep dive. And we have to separate two claims that sound almost the same but are in completely different legal worlds: unfair dismissal and wrongful dismissal.
This is an absolutely crucial separation for understanding your liability or your rights. They often come from the same event, the same firing, but their legal basis, the potential remedies, the requirements to even qualify, totally different.
Let's start with unfair dismissal then. We hear that phrase all the time, but what does it actually mean legally?
Unfair dismissal is what we call a creature of statute. It only exists because Parliament passed a law to create that right. And, crucially, it's not an automatic right. An employee usually needs to have completed a specific continuous period of service to even qualify for it. Its whole purpose is to protect people from being fired arbitrarily.
So what does an employer have to do to avoid an unfair dismissal claim, assuming the employee qualifies?
They have two big statutory hurdles to clear: reason and procedure. First, they have to prove they had a fair, legally recognized reason for the dismissal. The main fair reasons are things like capability, so you can't do the job, or conduct, you broke the rules. Then there's redundancy, which we'll get to next, illegality, or this kind of catch-all called some other substantial reason. Second, and this is just as important, they have to prove they followed a fair procedure. That means investigating properly, giving warnings, offering a right to appeal. If the employer fails on either the reason or the procedure, the dismissal is likely to be found unfair.
So it's all about the substantive why you were fired and the procedural how. It's there to protect an employee's job security.
Exactly. Now, let's pivot sharply to wrongful dismissal. This operates on a completely different level. It has absolutely nothing to do with whether the reason for firing you was fair or whether the company followed its own disciplinary procedure.
Right, because this is a common law claim, isn't it? It's all about the contract.
That is the key distinction. Wrongful dismissal is, quite simply, a breach of contract claim. And the most common breach is an employer failing to give the notice period that's written in the employment contract, or failing to pay you in lieu of that notice.
Okay, let's use a really sharp example to see how they work together. Say an employee is caught taking, I don't know, 50 pounds from the petty cash drawer. The employer is furious, fires them on the spot summary dismissal, and walks them out the door. The contract says they're entitled to 1 month's notice.
Okay, perfect example. This is where you could have two claims running at the same time. The employer would argue the theft is gross misconduct, which, if they can prove it, would allow for summary dismissal without notice under the contract. That act, firing for gross misconduct, gives them a potentially fair reason for dismissal under the unfair dismissal rules. The reason is conduct.
But what if the employee says they didn't steal it? Or maybe the employer just jumped to conclusions without a proper investigation.
Well, if the employer can't prove the conduct was bad enough to be gross misconduct, or if they failed to follow a fair investigatory process before firing them, the employee could bring a successful unfair dismissal claim.
Okay, but what about the contract breach, regardless of the unfair dismissal claim?
Now that's the wrongful dismissal claim. By firing them instantly, the employer has breached the contract term that requires notice, unless they can prove the employee committed gross misconduct. If a court later decides the evidence for gross misconduct was weak, the employee wins the wrongful dismissal claim for the loss of salary they would have earned during that notice period. They literally just get the money they were contractually owed.
That is a brilliant distinction. So unfair dismissal is about whether the state thinks your termination was just substance and procedure, and it's statutory. Wrongful dismissal is just about whether your employer broke their written promise, the notice terms, and it's common law. You could win one, lose the other, or even win both.
Yes, the employer has two completely separate lines of legal liability to worry about.
So let's move away from dismissals that are based on fault or breaking a contract and towards termination that's purely about business need. This is segment 3, the specific rules around redundancy. Now, that term is used incorrectly all the time just to mean I don't need this person anymore. But legally, it's much, much narrower than that.
That's absolutely right. Redundancy is distinct because the termination isn't about the individual's performance or their conduct. It's about the role itself. Legally, a redundancy situation happens when the need for employees to do a particular kind of work has ceased or diminished, or maybe the whole workplace is closing down. It has to be a genuine operational reason.
Okay, so once a company has established that a role is genuinely redundant, let's say they've automated the whole bookkeeping function, what are the specific rules that then kick in? You can't point at the most expensive person and say, you're out, can you?
No, you absolutely cannot. The rules around redundancy are all about ensuring procedural fairness. And this happens through two main pillars: objective selection and consultation. If you fail on these procedures, even if the business reason for the redundancy was rock solid, the dismissal can still become an unfair dismissal.
Right. Let's talk about selection first. If you have three people doing similar jobs, but you only need two of them going forward, how do you fairly choose who has to leave?
The selection criteria have to be objective, non-discriminatory, and applied consistently across the board. You have to define a pool of employees doing similar work and then pick criteria that are quantifiable. Using criteria like enthusiasm or cultural fit it's far too subjective and very risky. You should be using measurable things: verifiable skills, documented performance reviews, attendance records, disciplinary records, and you have to apply them impartially.
So it basically stops a manager from using redundancy as an excuse to get rid of someone they just don't like.
Precisely. If the selection criteria are biased or the whole process feels like a sham, an employee can challenge it and claim unfair dismissal. And this is where that second pillar, consultation, becomes so essential.
Consultation. Yeah, this often feels like a box-ticking exercise for employers, but the sources are really clear that it has to be meaningful. What does that actually involve?
Meaningful consultation has to happen at a formative stage, so before any final decisions have been made. And it must give the affected employees or their representatives a genuine chance to influence the outcome. The employer has a duty to consult on three main things: whether the redundancies are necessary at all, the proposed method of selection, and any potential alternatives to dismissal.
Alternatives, like maybe moving people to different roles or retraining or even just reducing hours instead of firing people.
Exactly. If an employer just announces on a Friday, "You're all redundant, effective immediately," and hands over a redundancy payment, they have completely failed the procedural requirement for consultation. And this is so critical that for large-scale redundancies, failing to consult properly can lead to something called a protective award, which is a punitive payment to the employees on top of anything else they're owed.
The application here is just so important, isn't it? If you're involved in any kind of restructuring at a company, these rules are the blueprint for avoiding huge legal problems. And if you're an affected employee, understanding your right to be selected objectively and consulted meaningfully, it ensures you get the due process the law demands when your job is cut through no fault of your own. And that brings us to the end of this pretty intensive deep dive into employment essentials. We've really tackled three crucial legal distinctions that govern the professional world.
To quickly recap what we've just unpacked, first, we define that legal gateway, the difference between an employee and someone who's self-employed. We emphasize the legal tests of control, integration, and mutuality of obligation, which look at the substance of the relationship, not just the label.
Second, we drew that sharp contrast between statutory unfair dismissal, which is all about the reason and the procedure and requires qualifying service, and common law wrongful dismissal, which focuses purely on the breach of the contract's notice terms.
And finally, we detail the procedural rules around redundancy, clarifying that when a role disappears, the process itself, from objective selection to meaningful consultation, has to be handled justly to avoid more liability. Mastering these distinctions is, I think, absolutely essential for anyone who wants to truly understand their rights and liabilities in the workplace.
So, if the legal system has spent the better part of a century building up these really robust distinctions, employee versus contractor, to provide protection based on things like control and integration, what happens now?
Well, that's the big question. If the protections for an employee are so different from those for a contractor, how does future technology, I'm thinking of fully decentralized, algorithmically managed workforces, how does that challenge or maybe even break down these old classification tests? When your boss is a non-human AI that manages your tasks, rates your performance, and calculates your pay, does the legal concept of control even hold the same power in granting fundamental human protections? That is the monumental legal challenge that's built right on the foundations we just reviewed. It's a puzzle for tomorrow that depends entirely on knowing the rules of today.